following program is a presentation of the Ohio School Boards Association.
What can schools do when a student's behavior becomes a serious safety risk? A new Ohio law just expanded what districts can do, and we're going to talk about it in this episode of the Legal Ledger Sidebar. Welcome to the Legal Ledger Sidebar, a podcast from the Ohio School Boards Association where we break down the legal issues shaping Ohio's public schools with information that's timely, practical, and easy to understand. I'm Scott Gerf, and today we're tackling a big update to school discipline procedures, House Bill 206. It gives districts new authority when serious safety concerns are at play. But there are some important steps to take first. John Price and Jennifer Hardin from OSBA's legal team are here to get us all up to date on this new law. John and Jenny, thanks for joining me.
Thanks for having us, Scott.
We always appreciate the invitation.
Before we get into the specifics of House Bill 206, can you give us a quick overview of how school discipline typically works in Ohio, especially the difference between suspensions and expulsions?
Sure, Scott. So both suspensions and expulsions are governed in Ohio under Ohio Revised Code 3313.66. And so basically a suspension is a shorter term removal, typically for less than 10 school days. And really, the process that districts have to follow is pretty minimal for suspension. The principal typically really just has to kind of meet with the student to get their side of the story. It's a very informal hearing process. The student has to be given notice, but that's basically what has to happen for suspension. For an expulsion, which is a longer term removal for more than 10 school days, the due process that the student and their family receives is more extensive. So they have to be provided notice of the intent to expel, and they have the opportunity for a more formal hearing before the superintendent or the superintendent's designee. And what's really sets that process apart is this expulsion piece involves the student's parent more extensively in the hearing process than the suspension would.
Yeah, John's right. A good rule of thumb is that the longer the expulsion is going to be, the more extensive the student's due process rights are. They have a right to their education. Mm-hmm. They have due process if that education is abrogated in some way. That means that if the district is planning on keeping a student out of the classroom for a long period of time, they're going to have more hoops to jump through.
And the last thing, Scott, that I would note for the law as it stands now is that in general, students in kindergarten through grade 3 should not be being suspended under a current Ohio law unless pretty specific exceptions are present.
So expulsions are longer term. They come with more due process. Is there a cap on how long an expulsion can last, Jenny?
That's a really great question, Scott. Typically, or a typical expulsion rather, under 3313.66 is up to 80 school days or for the rest of the semester where the violation occurred. This is kind of the baseline rule.
Okay.
There are several situations where a district can go beyond that 80-day limit. For example, the law requires school districts to expel a student for a year if they bring a gun to school, and that's consistent with the federal Gun-Free Schools Act. Districts can also expel a student for up to a year if they bring a knife capable of serious bodily harm or make a bomb threat. For all of these longer expulsions, they have some flexibility to reduce that time frame, even including the bringing a gun to school. They have some flexibility to reduce the time frame if there's a board adopted policy that allows that. And finally, there are situations in which a district can permanently exclude students, but we're not talking about that today.
So those are really kind of the basic parameters around expulsion as it has stood. Jenny's right about that. And then House Bill 206, which is what we're about to talk about, kind of adds on top of that.
So yes, that brings us to House Bill 206. You mentioned this new law gives districts a bit more flexibility when serious conduct is involved. John, what exactly does that do?
Yeah, so I think the best way to think about House Bill 206 is creating sort of a new category of expulsions options for districts when students engage in behavior that poses an imminent or severe danger to other students or staff. So the first thing that districts need to keep in mind, though, when we're talking about House Bill 206, is they do have to enact it in a policy. So it's not something that is going to automatically become an option without the district taking the action. So number one, you're going to need to work with your policy subscription service, OSBA, or whoever, to make sure that your policy enacts this process if it's something that you and your leadership team is going to want to do. So what that policy will allow the district to do is to expel a student for up to 180 days, so significantly longer than that initial period that we were talking about. And what's really interesting about it is it's a renewable expulsion period. So it's not just 180 days, we're done, the student comes back to school. There are processes in place by which that period of removal can be extended if certain conditions are present.
So, Jenny, a big piece of this is that assessment that the law requires. Walk us through how that process all works.
Yeah, happy to do it. So once a student is expelled under these new provisions, the district has provided all of the due process it's required to provide, the superintendent is then required to set conditions to bring the student back when the expulsion period ends. And the student has to meet those requirements in order to come back to school. They have to be provided in writing to the student and the student's parents so that they understand what the obligations will be. One of the required conditions in that list of superintendent conditions is that the district has to conduct an assessment of the student to see whether they continue to pose that threat to students or staff that John talked about a few minutes ago. The assessment has to be completed by a psychiatrist, a psychologist, or a school psychologist, and the district and the student's family have to agree on who's going to complete the assessment. Then there's the question of cost,
right?
And there's some kind of open-ended language here. But the district definitely needs to cover the cost of the assessment if it's their own employee who's conducting it or someone who's under contract with the district. If the assessment is done by someone who is not employed by or under contract with the district, the cost of the assessment is first billed to the student's health insurance, but the district's responsible for any remaining costs.
So, John, once that assessment then is completed, then how is it used? What happens next?
That's a great question. So essentially what happens is, as we're approaching the end of this initial period of removal, this 180 days, the superintendent is required to take that assessment and meet with what is called in the law a multidisciplinary team, which includes some school personnel and obviously the student and their parent, and really just look at it to determine whether or not the student has met the conditions for reinstatement that were outlined initially, like Jenny was talking about. So I also mentioned before that the period of expulsion is renewable beyond the 180 days. So really this is when that comes into play. So based on the results of that assessment and whether or not the student has met those conditions, the superintendent has the authority to determine whether the student's coming back at the end of that 180-day period, or if we're going to renew the removal for another 90-day period. If the decision is that the expulsion is going to be extended for another 90 days, then basically this process all happens again. So the assessment's going to happen again, the meeting with the multidisciplinary team, and we're going to look again to see whether or not the student has met those conditions.
Wow, there is a lot to unpack in this new law. So if you're watching this, maybe you watch it a couple times to understand all this. But Jenny, when we're talking about discipline, we can't forget about students with disabilities, and how does this new law handle those situations?
Okay, so before we talk about students with disabilities, let's talk generally about the district's responsibility to provide continued education to any student who's on either the 180-day expulsion or the 90-day extended expulsion. The superintendent has to meet with the student and their parents to develop a plan for how the student will continue to be educated during that period. That can be, there are a variety of different options mentioned in the plan. It can include a alternative school that's operated by the district, education in another district, or at a private school, or home education.
Okay. So.
For students who are receiving special education, the required meeting, did I say it had to be within 15 days? That's important. For students
Yes.
who are special ed students, that meeting has to be within 10 days. So it's a faster meeting.
Okay.
Right, exactly. And it has to also include the IEP team.
And I would also say, Scott, since we're talking about special education students, what I would encourage our viewers and listeners to remember is all of those rules around the manifestation determination review process, those procedural safeguards that students with disabilities have anytime we're looking at discipline for more than 10 school days, all that's going to apply as well. So districts are going to need to make sure that they're meeting all those requirements too.
So, yes, as with many laws, there's a lot going on here and a lot of boxes to check, I guess. Final thoughts. This has been helpful, and I know our members are going to probably, like I said, want to review this maybe a couple times or more, just to get an understanding of what's going on. But
Sure.
Any final takeaways before you leave?
When you're talking about checking those boxes, the first box the district is going to have to check if it wants to be able to implement this kind of discipline is that they have to have a policy.
Yeah.
So the board is going to have to adopt a policy regarding the removal of students whose actions are determined to propose an imminent and severe endangerment. It's not automatic. So make sure that your district is working with your policy subscription service to get that policy into place. And of course, make sure you're working with your legal counsel when you're dealing with a specific situation.
The thing that I would add, going back to some of the process that we talked about, the superintendent has a lot of discretion here to determine, whether or not this discipline is going to be implemented and for how long. There are provisions in the law that allow the superintendent to shorten the period of removal if maybe say the child meets those conditions earlier than everyone thought. There's a lot of strong language in there that really leaves this decision up to school leadership and the decision makers who have the information necessary to make those decisions. And also, I would just emphasize that these are not mandatory provisions generally. So, schools can really make decisions about what makes the most sense for them and individual situations and can really make those decisions.
Well, Jenny, thanks for being here and helping me and everyone out there understand what's going on with this new law. You want to make sure your board policy is up to date, as you mentioned, and also consulting with your legal counsel, right?
Absolutely.
Because these cases can get complex.
Yes.
Yeah, and people are always welcome to call OSBA's legal division if they have questions generally about the law. We're happy to help.
And that number...
OSBA Law.
You didn't forget this time.
855 OSBA Law.
So that's it for today's episode of the Legal Ledger Sidebar. Thanks for watching, and we'll see you next time.